podcast into Prof. Debrief situation report.
All right, we're good. This is SITREP, the podcast on Philippine affairs, Filipino interests. I'm Ivan at home from Manila. The arrest of former President Rodrigo Duterte by Interpol and his surrender to the ICC by the Marcos administration has triggered a legal debate here in the Philippines. No less than the presidential sister herself, Senator Amy Marcos, has opened up hearings in the Senate questioning the constitutionality of Duterte's arrest. All over social media, armies of wannabe lawyers with access to Google and plenty of time on their hands are bitterly arguing over it until now. On a grander scale, the arrest of Duterte has become a dividing line for many politicians as the crucial May polls approach. To give us clarity on this important topic, we at CITRAP invited Professor Michael E. Chu Jr. of the University of the Philippines, Diliman. Professor Chu is assistant professor of the UP College of Law. He is concurrently the head of the International Criminal Law Program at the UP Institute of International Legal Studies and head of the UP Law Center's Information and Publication Division. Professor Chu is also legal consultant with the United Nations Office on Drugs and Crime under the UN Joint Program for the Promotion of and Protection of Human Rights in the Philippines, and he is also consultant at the Supreme Court of Gender Policy and its committees on the revision of its rules. Professor Chu is lastly consultant on the Commission on Human Rights for matters of international law and human rights. And we think he's the perfect person to bring to this discussion. So without further ado, Professor Chu, welcome to SITREP.
Thank you very much, Ivan, for inviting me to SITREP, and good morning to everybody listening in Manila, in the Philippines, and elsewhere.
Okay, thank you so much, Professor. So before we start, perhaps you can briefly tell our listeners about yourself and how you got interested into the field of international law.
Well, I've always been interested in global politics, even when I was still young. I took political science as my undergrad, and their international relations has always been an interest just because of how dynamic it is. When I went to law school, I focused on, you take everything, but my interest took me to public law, in particular constitutional law and public international law. And there it's the same idea of politics and global relations and how state interests interact in that global stage that really brought me to this field. It's very interesting to analyze such an ever-changing environment, and of course states will have different interests. So just because of that dynamics and how states project their interests even when they actually have different interests that they keep hidden, it's always such an interesting thing to study, because first, they're not natural persons, and so you can't really read their minds. And of course, they have domestic processes like ours that you also have to take into account. So all these are just very interesting to me.
So perhaps to start off the interview, we can lay out, the overall view of things. Perhaps you can briefly remind our listeners how we got it to the point right now that the former president of the Philippines has been arrested and is facing trial in the International Criminal Court. How did we get?
So we got here because of the war on drugs, which actually is something that I really don't want to call the war on drugs, but that's been how it's colloquially referred to. But it's mostly because of the killings, although not just the killings, but because of that, and the families, victims have filed submissions, communications with the International Criminal Court, and that's also largely because they didn't see any hope of justice in the Philippines, because the one that's allegedly doing the killings, and I think it's also been admitted by the administration then, was the government, was the state. And so there wasn't any hope of getting that justice here. Even cases being filed were not thinkable during that period. So people turned to international institutions, the International Criminal Court, to get justice. And the families of victims and some of the victims themselves who escaped death filed communications before the court. The Office of the Prosecutor began investigating in this process called preliminary examination. And it got to a point where it had enough to ask authorization from the pretrial chamber of the International Criminal Court to open an official investigation. That happened in 2021 when the pretrial chamber allowed the opening of that investigation. And it's been going on. In fact, this entire stage at the International Criminal Court, it's still at the investigation stage, except that they also were able to arrive at the point when they could identify at least one person who they believe has reasonable grounds that this person had committed the offenses that had been charged under the jurisdiction of the court. And that, in this case, that person is former President Duterte. But that's not to say that there won't be others who might be also involved or issued warrants of arrest. But for now, we have a warrant of arrest against the former president, and that was implemented, as we saw, in March, and he was surrendered by the Philippine government to the International Criminal Court. So at this stage, he is already detained at the International Criminal Court's detention facility, awaiting this proceeding, which we call confirmation of charges. So it's actually a make or break stage of the proceeding. So from the name itself, this is the stage where the pretrial chamber will determine whether charges will be confirmed, i.e., if it's confirmed, then the trial will proceed. Otherwise, and if it's not confirmed, then there will be no trial, at least for President Duterte, unless the other side or the prosecutor wins it on appeal.
And just a quick follow-up to that, Professor. There's reports coming out of The Hague at the moment that the ICC has already on its hand at least 2 witnesses linked to the Davao Death Squad, 16 hours of audiovisual material, and pages upon pages of documents. Do you think, personally, in your opinion, that this is sufficient to pass the pre-trial stage and to allow hearing to take place? Or
it could be, and that's because we're in this stage now called the disclosure process. So there's a different kind of setup for international institutions, particularly for the ICC, that we're not used to, because in the Philippines, largely, and I think the rules will also change towards this trend to adapt to this trend. But for now, we have a system where people hide evidence from each other until they're forced by the court to disclose. But that's not the case for international institutions. It's a transparency proceeding, and so you have to tell each other what evidence you have, so you can adequately prepare your case, knowing what evidence the other side would have. So we're at that stage, and so the reason why we know that there are 2 witnesses and 16 hours of recording and documents is because the prosecution said that that's the evidence that it would present during confirmation of charges. So I think that it could be enough, because we're not yet at the stage of the trial where everything has to be laid out. So what we have at the confirmation of charges, possibly, and for the lack of a better term, is a sampling of the evidence that the prosecution has, because they only really need to satisfy this particular standard, which is substantial grounds, that there are sufficient evidence that there are substantial grounds to believe that this person committed the offense or the crime that was charged against this person. So it's basically just a slice of the evidence to support that substantial grounds standard, which is quite low when you compare it to what you need to be able to convict a person after trial, which is guilt beyond reasonable doubt, something that we're familiar with. So I think it could be enough. We will see still. The quality, it's a different quantity, of course, is one thing, but the quality of the evidence that might be presented during confirmation of charges is still up in the air. We don't know who those witnesses are yet. So we will see if the testimony, I don't think the prosecution will present anybody who might not be able to speak to the facts in this case, because that'll just be, shooting themselves in the foot. But we'll see, and that's going to happen in September, and they're all going to be disclosed unless confidentiality is requested to protect the witnesses.
As a preeminent professor on international law yourself, what was your initial reactions when you saw those scenes in the airport and him being dragged to The Hague? Well, what's your initial reaction when it comes to this arrest?
Well, it was. I didn't think it was out of the ordinary, really, because the other defendants who have been transferred to The Hague, in fact, some of them even had more dramatic transfers. This one was largely peaceful. We noted some commotion on the part of the family and friends of the former president, but um, this was largely uneventful, save for the fact that I think the remarkable thing about it is, for one, that our own Philippine government transferred its former president. That's not usually the case, or that wasn't the case for the others who were not transferred by their own government. Some of them were transferred by the governments of the states they were found in at that particular time, or other third states where they traveled to. But here, that this is our own government that transferred a former president. So that's, I think, remarkable. The other thing is how fast it was, which is what makes it different from past surrenders, because they usually took days to happen. But this one happened within a matter of hours in a single day, which really tells you as well that there was some preparation for the transfer. I think we've been hearing for a while anyway that there might be a warrant of arrest that would be issued. So the government, like any other entity that prepares when that news comes out, was prepared for this one. So I think just as a matter of international law at work as it interacts with domestic proceedings, it was certainly, I would say some aspects of it would be the first of its kind. Also because this is a crimes against humanity charge, and the others in the past where surrender had happened largely pertained to war crimes, but this one was like crimes against humanity that happened during times of peace.
I think it's fair to say that on social media right now, and even on mainstream media, there's a lot of how we can say misinformation with regards to the legal basis for the arrest of Mr. Duterte. So perhaps we can go at it in a very systemic way to debunk a lot of this. We can start with jurisdiction. Can you explain to our listeners, Professor, what is the legal basis for Duterte's arrest at the ICC? Specifically, there's a lot of questions on how the ICC can claim jurisdiction over crimes committed in the Philippines, given that we withdraw from the Rome Statute in 2019.
Okay, so jurisdiction, I think, is presented as such a problematic, and I think there is merit to the counter arguments. But let's take a look at what we agreed to when we entered or became state party to the Rome Statute. First, we agreed, and this started in 2011 when our Senate ratified or concurred in the ratification of the president. So we agreed that the ICC has jurisdiction over crimes committed in the territory of a state party, i.e. the Philippines, during the time that the statute was effective. Okay, so the charge in this case spanned, I think, 2016, maybe some years before 2016 until 2018. Or 2019, before the effectivity of the withdrawal. So temporarily or time-wise, there was jurisdiction over these crimes because we agreed that the ICC will have jurisdiction of crimes, again, that happened in our territory during the time that we are a party to the Rome Statute. That's one. The other thing is that the Rome Statute has this, we agreed to this as well. And there is a provision in the Rome Statute that says, and this is Article 127, Paragraph 2, that says that matters already under consideration by the court before the effectivity of the withdrawal of the state from the Rome Statute shall not be prejudiced by such withdrawal. So we can imagine why that might be, because when they were entering into the Rome Statute, everybody thought that it's very likely that if your officer, president, head of state, whoever it is, will be charged under the Rome Statute, then states will simply withdraw from the Rome Statute, so to avoid accountability or to protect somebody. So, the states who entered into this treaty were very conscious of that, and they provided a mechanism, a safeguard, so that states will not be able to evade. Now, the question is whether this was already a matter under consideration. There's some debate about that, but the pretrial chamber, the ICC, already said that it has jurisdiction. So that's not. So I think that's a fairly reasoned conclusion by the pretrial chamber. We all know that there were dissents at the appeals, but that the dissents didn't win. But I do think that this entire exchange about jurisdiction will play out again because the accused, well, in this case, the suspect, because their charges are not confirmed yet, has another opportunity to raise the question of jurisdiction. But just as a matter of law, and in my view as someone who's a student in this field of law, I think that there is jurisdiction in this case because, again, what we agreed to was the ICC will have jurisdiction for crimes that happen in our country at the time when we are parties, and that's the case here. We were parties from 2011 to 2016 to 2018, 2019-ish, when the effectivity when the withdrawal was not effective yet. So that was well within the time limit. And then again, Article 1272 that says that you can't just get out of this accountability regime by simply withdrawing. If we started an investigation before then that's well within the jurisdiction.
My next part of the question, building on from jurisdiction, is the question on obligation. Because I remember a hearing before with the House with former Justice Secretary and now the Solicitor General Martin Guevara, saying that a lot of this, at least from the perspective of the Philippine government, is based on political discretion. Now, naturally, there are, and I think that's also a sentiment held by the Duterte camp, because they're repeating that if the palace didn't want to, they could have prevented this. They could have ignored the ICC warrant, could have ignored the summons by Interpol, etc. And so, did the Philippines have a legal obligation to comply? And I believe the Supreme Court already had a decision about this before. Well, you hinted the Supreme Court, but what's the current Philippine legal jurisprudence on whether we should comply and whether the president is bound to comply?
Well, let's talk about that decision first of the Supreme Court, which is, I think, what you're referring to is Pangilinan versus Cayetano, where the Supreme Court had to decide whether the Philippines had validly withdrawn from the Rome Statute, even when the Senate had not concurred in that withdrawal. So it was simply the action of the executive, in other words, unilateral. So that was the question that was resolved in that case. And in fact, the question was resolved based on the idea of mootness. No? So at that point, when the challengers brought that particular question to the Supreme Court, so many events had already happened that the question or the issue had been mooted. So the court could really just have stopped at that, but it didn't, because it wanted to provide certain guidance to the bench and bar on that question. But I think just if you look at the decision closely, one would really say that, well, the court did say that, as I was mentioning earlier, there's Article 1272, where you still have residual, if you want to call it that, residual obligations even when you've withdrawn. But I think that was a side discussion, and that really wasn't the meat of that case. So we want to be very careful about what the Supreme Court actually resolved in the Pangilinan case, and that's not, the court did not resolve really whether we still had obligations under the Rome Statute. It discussed it, but it wasn't necessary in the resolution. But that being said, we do have that statement from the court in that case. Now, the other thing is they're right, and this is the government frames and states that this was in compliance with the obligations, and note the careful language here. This was in compliance with our obligations with the Interpol. to be fair, the Interpol helps us a lot because if we want people to be extradited back to the Philippines or we issue a warrant of arrest to somebody, the Interpol helps us implement that. In the case of, let's say, former governor, former congressperson, um, I forget his name, but the one who is in Timor-Leste now. Uh, so, yeah. So the Interpol helps us there, right? So I think that's what the Philippines is saying, that we know if this is our turn to cooperate with the Interpol, our obligations. But I also don't see any problem. I mean, they're right. The other side is right in the sense that could the Philippines have ignored the warrant of arrest? I think so because the Philippines is not saying that it's cooperating with the ICC, right? It's cooperating with the Interpol, but the warrant of arrest was issued by the ICC. Even so, I think it could have ignored it. Like I mean, the U.S. does this a lot, right? Too. I mean, it's international obligations. It if it's not in its national interest, it will often ignore, even if there's an obligation under international. That's just the reality of global politics. But that's not to say that that the Philippines, even if it does not have an obligation, cannot do what it wants to do. In other words, international law operates based on state consent, right? So whatever the state wants to do, it can do under international law, except for specific prohibitions that you cannot go to war or cannot use force in certain circumstances. So there's also nothing wrong, even if we're no longer members of the ICC or the Rome Statute, for the Philippines to cooperate voluntarily. That's the nature of international law, no? We don't need to have an obligation to cooperate. So if the Philippines wants to cooperate with the ICC, it can do that. When it seems like when people talk about, well, it could have ignored the warrant of arrest, they could have ignored the warrant of arrest, true, but they could also just choose to implement the warrant of arrest even without the Interpol. So there's nothing wrong with that as well. So it seems like the framing of that question is, it seems like if there was no obligation on the part of the Philippines, then it was obligated not to cooperate. That's not true. I mean, let's look at this in this way. So if you owe somebody some money and a long time has passed and that person has not collected that loan or that money, and therefore the right has been lost through time, right? So, but it doesn't mean that the person who owes the money cannot voluntarily pay that money, even if there's no obligation to pay it anymore. I think that's what the Philippines did here. If you really want to look at what happened here, it can do that.
Yes, because I think what the issue that's now on social media is that people are flashing that video of Senator Amy Marcos as if demeaning or belittling the weight of the ICC of the Interpol arrest warrant. I guess as a clarification question, how much legal weight or political weight or moral weight does the ICC red notice actually have? Does the Interpol red notice?
I think just as a matter of comity and respect for our commitments, it does have weight because, again, we ask for the Interpol's help all the time. For people, let's say, who escape the Philippines, and they have cases here, and we issue warrants of arrest against them. The Interpol helps us implement those warrant of arrest if they're found in another country, as in the case of that former governor who's now in Timor-Leste. So I don't recall. I think it was a red diffusion, not a red notice. The only difference there is really that the notice or the document was issued not by the Interpol, but the ICC itself. But there is weight to that because we can't ignore it now, and then in the future we're going to ask for help from Interpol again. And so, I mean, there's well, why would they help us if we keep ignoring our obligations to them? So there is weight to that, but that's certainly not the end all and be all of this entire. So anyway, even if we remove the Interpol from the picture, the Philippines could is well within its sovereign prerogative to cooperate with the ICC, even if it's not a member of the Rome Statute anymore.
Thank you so much for that clarification, Professor. Duterte's legal team is now in the media right now, arguing that the arrest of Duterte violates Philippine sovereignty and the constitutional protections that should be granted to him under under Philippine law. They're saying that he should have been tried. He should have been tried in domestic courts, and from a constitutional perspective, uh, is there merit to that argument, or does the international law take precedence over this case? Because Senator Marcos and her recent resource persons are saying and implying in the Senate hearings that this arrest violates Bill of Rights protections. That that this is also his legal defense uh, being repeated by Kaufman over at the Hague that his constitutional rights to due process was violated. What's your reactions to these statements?
Yeah, that's a very interesting question because we do see two fields of law interacting, that makes this issue arise, right? Or that creates this question. So I think that as a matter of international law, and I think I'm in the minority on this question. This entire proceeding is governed by the Rome Statute, right? Which there is an Article 59 in the Rome Statute that says that the arrested person will have to be brought before a competent judicial authority, where there's a certain proceeding that must happen. And I think when you read the ICC decisions, to me, that had been complied with, although I think Article 59 applies, and a lot of lawyers are saying that it doesn't because we're no longer a state party. So I think what applies is the Rome Statute because the warrant of arrest is from the Rome Statute, and international law governs this proceeding. So this is not a case where it is the Philippine government that is exercising its authority over this person, and the control over the person of former President Duterte is within the Philippine state, in which case the constitution will be very much at play. So here we know who has control over his person now. It's the International Criminal Court, not the Philippine state. That being said, there are, and this may be something that the Supreme Court will have to resolve in all those habeas corpus or even certiorari petitions filed by family and supporters of the former president, whether what is the extent of constitutional protections that must be accorded to former President Duterte in this case. So I think we know from the facts, or at least from the account of the DOJ, that he had been read his rights. He had been informed of the content of the warrants of arrest at the time when he was arrested. He had been given access to counsel, and he had advice from that counsel, from his lawyers during that time. And he himself, anyway, is a lawyer, so should know what to do. In fact, he was a prosecutor before, so this is nothing new to him about what the rights of the person under arrest would be. And I think that's what the Constitution requires, right? So
Yes.
there's a debate about whether all the other constitutional rights will attach to him. But I think in most of the context where we see those other rights playing out, the person is charged before Philippine courts, right? So the entire corpus of domestic law, including the Constitution, will apply to this person. But this is a very peculiar situation in which this person is no longer within the control of the Philippines. It is within the control of an international tribunal, international criminal court. And so what would apply to my mind is international law. So the initial protections, I think, have been satisfied, basically what the Constitution requires when you arrest somebody. But all the other things that follow, let's say protections during trial, etc., no longer apply because he's not being tried by a Philippine court. He's being tried by an international court.
Just to clarify, Professor, to build on what you're saying, under the Philippine Constitution, citizens are entitled to due process and protections from arbitrary arrest. but it is in your legal opinion that Duterte's arrest and transfer to The Hague aligns with these constitutional guarantees, and there is in no way a conflict being between international law and Philippine law, because it's potent political ammo right now in our, especially as the elections take place, that certain camps are saying that the Philippine Constitution was overwritten by a court document. How is this not true?
I think they have to specify which parts of the Philippine Constitution had been um, upended, overridden by what happened to the former president. Again, the Constitution requires that if you arrest somebody, there has to be a warrant, right? That warrant must, the contents of those warrant must be relayed, or that person must be informed of the charges, the so-called Miranda rights, right? So when you arrest a person, you have to advise that person that he has a right to remain silent, that anything will be that he or she says, will be used against him or her in a court of law, that he has a right to an attorney, and if he cannot afford an attorney of his own choosing, one will be provided for him or her. So I think from the DOJ's account, and if we find that to be true, those things have been done, right? He also had been given advice by his own lawyers, and I think we saw some videos of that too. So that's what the Constitution requires for this particular instance. No, so the question is, are the other things that are required by the Constitution, like right against self-incrimination and all those things, those usually play out when they're before Philippine courts, but again here that's not the case. The other thing is like due process, right? So section 1 of article 3 does say that no person shall be deprived of liberty without due process of law. So that's where the arbitrariness comes from. So for one, we cannot say that there was no basis. In other words, it was not arbitrary because he was not arrested for nothing, right? He was arrested because there was a warrant of arrest from an international criminal court, which had jurisdiction of those crimes committed during a time that we were a member. So there's a basis for the arrest. It was not some random picking up of a person. So that's one. The other thing is, what does the Constitution require to be given? Due process, right? So it means process, or if you want to play with the words, it means process that is due, no? So for that particular scenario, so again here we have to think of, well, what process is due in this instance? It seems like the Rome Statute does say what that process is, and so if that process was followed and it's the process that is due, then the Constitution is not violated.
Uh, Responding to what you said, Professor, perhaps you can respond to some Duterte operative talking points, because a lot of their operatives right now are basically saying that that this move undermined the Philippine legal system on two counts. And the first count is that the ICC operates on a principle on complementarity, meaning that it only steps in when the national courts are unwilling or unable to execute. So I guess you can explain to our listeners, how did the ICC justify intervening in Duterte's case, given that, according to the opinions of some people, the Philippine domestic judicial system is, quote unquote, still functioning. And certainly his supporters would insist on that, and many politicians would insist on that. And then, how do you agree with their assessment? And I guess you can answer the question how you will.
Right. I think we may start with, I find it odd, really, that complementarity is invoked at this stage, because complementarity is the system put in place by the Rome Statute precisely to give deference to national jurisdictions, national courts in trying these cases. But it's odd that it's being invoked now when President Duterte's own administration withdrew us from the Rome Statute. So if he wanted the protection of complementarity, we should not have left the Rome Statute, because that's the entire system of the ICC. But because we left the ICC, we don't get the protection of that system anymore. Okay, that's the first level. But I think let's engage with that argument in good faith and say, okay, fine. Let's say we accept that it applies. So the you're right about complementary. So the idea is from the word itself, complement, right? So the states who entered into the Rome Statute thought that the first instance of trying these cases should not be with the International Criminal Court, because you do have states who are sovereign and who have their own legal systems. So the Rome Statute says that the one who gets first crack at this will be the national institutions of the state whose national is involved or who has jurisdiction. So that will, and that, in other words, the national prosecution will prosecute this case. The national courts will try this case at the first instance. No, so the International Criminal Court will only come into the picture when there are other things, but basically when the national government or the national jurisdiction is unwilling or unable to prosecute or to investigate the person involved. Now, so let's look at that scenario where we unwilling, and this is an or situation, right? So unable, that's the part where they say, well, our national courts are not breaking down, etc. So we have national courts, but it's an or situation. It's not an and situation. So we were unwilling because, I mean, prior to this arrest of President Duterte, was there ever a case against President Duterte before any of our national courts? I don't think so. So the test here is to satisfy complementarity is the same conduct, same person, same conduct test, right? So what does that mean? So in order to satisfy complementarity or the unwilling or test, unwilling or unable test, your national courts should be, number one, investigating or prosecuting or trying the same person named in the warrant of arrest. I don't think we have any case in any of our trial courts that accused former President Duterte of anything involving the war on drugs. What we do have are cases against police officers, against foot soldiers. You know, so in the grand scheme of things, these are the police on the ground who implemented the policy. But we don't have any of the big guns, those who planned, designed the war on drugs, who were considered architects of this policy in any of those cases before being tried before our courts. So that's one. Same conduct. Even if we do have cases before, let's say, former President Duterte, just assuming for the sake of argument that we do have those cases, is he being tried for the same crime in the warrant of arrest, which is crimes against humanity? We also don't have that, right? So if the same person, same conduct test is not satisfied, then the ICC will come in because it will then see, okay, well, you have all these, well, one, you don't have these proceedings, right? So how are we going to make these persons accountable? Next, even if you do have these proceedings, they look like they're facade, no? They're not really going after the right person or the mass. You have to remember that the ICC tries often the most senior, the high level people, because the assumption in the first place why the ICC is created is because these crimes are perpetrated by persons of the highest levels of their governments, of their states. And we cannot expect those states to try those very powerful persons, right? So if we are to create a system that they don't escape accountability, then the International Court is there to fill in that gap.
And I guess it's worth noting also, Professor, that the very point you made that complementarity doesn't apply was repeated by Justice Secretary Romulia himself in the Philippine Senate, saying that, in the opinion of the Philippine government, they were no longer obligated to provide those complementary protections to Mr. Duterte. What was also interesting was when he noted that he implied that it was impossible for us to conduct proper cases here because for 90 to 95% of the deaths, the evidence was either, and the initial police reports itself was either not present or was completely fabricated or meddled with. And then the second point that the Duterte supporters bring up is that the this was repeated by Salvador Metodea and now Nicholas Kaufman over at The Hague. They said that his transfer to The Hague was an extrajudicial rendition. It failed under basic ICC protection. It was kidnapping. And legally, how does Duterte's transfer to the ICC differ from the standard ICC extradition process protections that's under the Rome Statute? And was it conducted in accordance with international law?
I think it was. Again, there's disagreement. So again, it was not kidnapping because that doesn't. I mean, he wasn't taken out of the blue. And there was a warrant of arrest. That was the basis for taking his person and surrendering him. And the government cites RA 9851 that allows it to surrender. It wasn't extradition as well because we don't have. It doesn't apply because this is not a state-to-state situation. So that's not. It's really just surrender, as the state mentioned. But I think it was in accordance with international law. So again, other lawyers disagree that Article 59 of the Rome Statute applies. I am inclined to think that it does. Otherwise, there will be no process for transferring. If the Constitution or if the domestic law does not apply and Article 59 does not apply, there's no process that applies to the surrender of this person. So I think Article 59 applies here as well, even if we're no longer members. So, but even then, even if I think it applies, I think it's been complied with because in the previous cases where the court had looked at the Article 59 issue, the International Criminal Court had said that the state that implements the warrant of arrest has a lot of leeway in terms of what that process could look like. So, and in fact, in one case, in the Ongwen case, it's the same. The Ongwen was brought before the prosecutor general, not of his own state, but of another country. He was informed of his rights in that country, and then he was transferred to the International Criminal Court. I think that's largely the same here. Former President Duterte was brought before the prosecutor general. He was advised by the police officer serving the warrant with his rights, and he was transferred. So I think that it complies with Article 59. Of course, we can anticipate that the defense will raise very specific particular issues because the Rome Statute also does say that implementation of the warrant of arrest will make reference to the national law of the country. So I'm sure they will say, well, that national law includes all these other constitutional protections. He should have been brought before the court. And initially, I was thinking that as well, that he should have been brought before the court. But after looking at the decisions of the International Criminal Court on what procedure is sufficient to comply with Article 59, it doesn't seem like it's a very stringent one. I mean, it gives a lot of discretion to the implementing state as to how they will design for that to play out.
All right, we're nearly done, Professor. Thank you so much for your time. So, Duterte, wrapping up, Duterte supporters have filed a petition to the Supreme Court stating that the ICC lacks jurisdiction over this country's withdrawal. They're arguing constitutional breaches. Meanwhile, the Philippine government is arguing that this was in compliance with RA 9851, saying that we have the right to surrender people to foreign courts at the discretion of the executive. They're saying this is a test case. Basically, how do you see these cases play out? What's the legal prospect for Duterte's motions at the Supreme Court? And could it really impact ICC proceedings as they intended to do?
So I wouldn't want to preempt the Supreme Court because, again, this is a novel issue. They have not ruled on this particular specific issue in the past. So We have to wait and see what the Supreme Court does here. There's one thing that I can say is that jurisdiction of the International Criminal Court is not determined by any national court. No, so state A or state B cannot say that the ICC has jurisdiction or not, because that's not within their power. The only institution who can say that they have jurisdiction or does not have jurisdiction is the International Criminal Court. Any court would be jealous of that question. So the other thing is, will it impact the International Criminal Court's proceeding? I don't think so, because it doesn't matter to them what the Supreme Court of any country will say about the proceedings before their court. I mean, they have control over their own proceedings and they apply their own law. And so they're the ones who are going to say whether certain things were violated or not. So because if that were to happen, that a domestic court, even a Supreme Court of any country, is able to say that what's happening at the ICC is illegal, then the powers of the ICC will completely be obliterated, because any domestic court can say that, and therefore it loses control of its own mandate. So it is only the International Criminal Court who can say first that it has jurisdiction or not, and that whatever is happening before it is consistent with its statute and its rules or not. So no domestic court can affect that. No. The other question is, well, if the Supreme Court does say those things, who will be affected? It's going to be Philippine officials, especially for habeas corpus proceedings. The order is against Philippine officials. So they cannot order the International Criminal Court, but they might order Philippine officials to do something. And how that plays out will then become a matter of international relations, because it will transcend our borders.
Looking forward to Duterte's trial, what constitutional and legal challenges do you expect to arise during this entire process, particularly, witness protection, evidence admissibility, and what are the potential appeals that you expect the Duterte camp to bring in order to hamper the process?
Well, they have the accused is assuming that the charges will be confirmed in September. The accused will have a lot of protections. In fact, I don't know why people are so concerned about the ICC, really, because if you look at its history, it's very, very careful in protecting the rights of the accused, to a fault, even, because it is conscious of its legitimacy as an institution. It doesn't want to trample on the rights of individuals in these big cases, because these are states versus individuals sometimes. So they're very careful about protecting that. So you can imagine that there will be challenges to the evidence. There will be challenges to the reliability or the probative value. So admissibility is not so much a big question in any international court, in particular the International Criminal Court, because it's a mixture of legal systems. Then they don't use the very strict rules of inadmissibility like we do in our Philippine Constitution. So what they do is that they assess the totality of the evidence, or one evidence relative to another, one piece of evidence, and if it's relevant, then they will admit it. They can even admit hearsay before the International Criminal Court, just as long as it's relevant and there's some other thing that supports the account of the person or the witness, even though it's hearsay. So it's really probative value versus more than admissibility that they will look at. So I don't think any challenge or most of the challenges would be successful in that way. I do see some chance in the challenges of proceedings with respect to the how the person might have gotten to the court. I know some lawyers say that it really doesn't matter how he had gotten to the court. I think that might still be something that the defense will harp on. And of course, the court will have to confront that issue of how he was arrested and was eventually transferred to the court. And then just later on, I think what they did with identity cards of potential victims participating or witnesses participating, they were going to challenge um, the identity of the victims. I think we also saw some challenge about the number of victims. So basically, element per element of crimes against humanity, they're going to attack because it is in fact a very different crime, right? So what is being punished here is not just murder per se or the killing of person. What is the very evil in crimes against humanity is that you committed all those killings in a systematic or organized or widespread, a widespread systematic or systematic fashion. So it's like large scale kind of situation. So we can anticipate challenges there as well, that it wasn't really widespread, that it was not systematic. So these are what we call contextual elements. And even if we have those, we still have mental elements, you know. So he didn't have the intent of killing those persons, and that's when all the
We're just
narratives,
joking. Can they say
yes,
that? He was
or
just joking.
um, it they can, but it's not very smart to say that because you know, I mean, the judges are not stupid. They can see right through it.
Got like 16, they've got like 16 hours of audio logs of him saying such things.
Yeah. And you know, I mean, in all his sona, in all his press statements, he did make those. So I don't think there's a question about whether there was a policy relating to the war on drugs. But I do think that they might raise things like the usual non-laban rhetoric or defense that the intention really was not to kill these persons. They were supposed to be apprehended, but the killing was necessary because the police were trying to defend themselves. We can kind of anticipate hearing those same defenses again, and that will really go into what was the intention of the war on drugs. Was the intention to kill these people? And they might say, well, we didn't intend to kill them. It was in self-defense that they were killed, but that was not the intention. The intention was to arrest them. In fact, all the other people who surrendered were not killed, right? So you will see those play out. So there will be various defenses that will be leveled, and I think they will. I do think he has competent lawyers. So, I mean, that's important so that, you know, you cannot later on challenge and say, I did not have effective counsel. So I think that's important that he has really good lawyers because the prosecution will want to prove their case, even with that kind of the quality of the lawyers on the other side. And I do think that just looking at, I mean, we're all in the Philippines. I was in the Philippines when all these things were happening, and we did see them play out on a daily basis. So I think there's enough evidence. It's just a matter of whether the evidence are presented in a way that targets all the elements of crimes against humanity.
And just to close it off, Professor, do you have any last closing comments on how this process is playing out? Like, is it going well? And what does this say about where we're moving as the Filipino people?
Yes, I think it's playing as it should. I think the International Criminal Court has been following its procedure to a T, and that's really important. It's a really professional court. They are so used to all these challenges because it's been there since what, 2002. So they're in, you know, they've handled more complicated trials as well. So I think it's proceeding as usual. I do think that we have to reflect all this resistance to the International Criminal Court. For one, again, the things that we say should be protections that have not been accorded to the former president was really all because we made that decision to leave the Rome Statute. So, you know, you can't have your cake and eat it too, as the saying goes. That's one. And the other is, well, we have to reflect, like, why are we resisting the International Criminal Court so much? When we entered the Rome Statute in 2011, and even before then, the process was already ongoing. For what purpose? Because we want to participate in a system that makes sure that those who commit these grave crimes, it's genocide, crimes against humanity, war crimes, to be held accountable. And we agreed to a system where we'll take a first crack at it, and then if not, then the International Criminal Court. But the bottom line is accountability. So what is the resistance all about? Is the resistance that we don't want our politicians, former leaders, to be held accountable for their crimes. Because if the narrative is we can try them in the Philippines, but we haven't been very good at showing that that's true, right? I mean, he has been out of office, um, and even if well, because we can anticipate that there wouldn't be, or we can rather realize that there wouldn't have been any case against him while he was president, right? Even if there was no legal block really. um, but he has been out of office since 2022, and there had been no cases filed against the former president. So I don't think it's true that even if our courts are functioning, that he would be tried in the Philippines. I don't think anyone has dared to do that. So I think let's be honest about this resistance, no? So this legal acrobatics of trying to justify getting him back, if you're going to be honest about it, it's really just naked assertion that he should not be held accountable. At some we do hear this from some other people who say that, well, it wasn't a crime, he was trying to do his job. At least we can see that there's no moral problem on the part of the people who say that, who continue to support him despite clear evidence of killings. At least they're honest about that. But for those who are trying to justify getting him back on legal grounds and you twisting all those rules, just say you don't want him to be held accountable, because we've had so many chances to hold him accountable for those crimes, but it doesn't seem to have played out in the Philippines. So what are the victims supposed to do but turn to an institution who could give them justice?
Professor Michael Chu of the University of the Philippines, thank you for being a guest on SITREP PH. Where can people find your work if they want to discover more of it? And you've got any major events or works coming up, where people find you in social media?
Right. So it's a good old LinkedIn and Google, the website of the UP College of Law as well. You'll find my work there, but really Google is enough. You can type in and then you'll see whatever it is that I've been working on in the past.
And this has been SITREP PH, the podcast on Philippine affairs and Filipino interests. This has been Ivan coming to you live. Be sure to follow our social media for updates on our upcoming podcasts and access to our old episodes. We are at SITREP PH on X and on YouTube. Like us on Facebook at facebook.com/SITREP PH. Philippines, thank you and good night. Thank you so much, Professor.
Thank you so much, Ivan.